We acknowledge the First Nations people as the traditional custodians of the land we are on today. We acknowledge and pay respect to all elders past, present and emerging.
The Now in the Future podcast is an exciting way of sharing members' stories of opportunities, challenges, and provide support and expert advice for Down syndrome community.
Down syndrome Queensland's vision is to support, advocate for, empower people with Down syndrome to take their rightful places as valuable and contributing members of their community both now and into the future.
Hi, my name is Michael Harrison. I'm the Community Engagement Manager at Down Syndrome Queensland. On today's episode of the Now in the Future podcast, we talk to Dion McCurdy, Principal of Direct Lawyers, about the subject of will and estate planning, essential for any person with an intellectual disability and planning for the future. Welcome, Dion.
Thanks, Michael.
So to start with, how about you give us a rundown about yourself, your business experience, and what sort of line of work and what you've done in the wills and estates area?
Yeah, sure. Absolutely. Thank you. So I have worked exclusively in this succession law area, which basically, we talk about as wills and estates. It's broken up into estate planning, which is, preparing for death and all the legal documents that we put in place. Estate administration, which means to look after, the actual paperwork essentially when somebody has died. And I've also worked in litigation, which is where people sue each other over, a loved one's death. And then it's a very unfortunate area that exists. So my experience has been, I've been working in this area for about 7 years now, and I was very fortunate enough to work for a boutique firm when I started out, which only worked, specialized in this area. And I've had my own practice for about a year now, and I work largely in the estate planning area, but I'm starting to expand into other areas. Other than that, in my life, I like to play volleyball and I like to swim. I volunteer for an organisation, an AIM mentoring experience, and I've started to have this connection with DSQ, which I've appreciated, and so that's I guess that's a bit about me and my background.
Fantastic. So the first question is, when is a good time to start planning for the future?
I think there's no time better than the present. As long as you're 18 years of age, you can make a will, and everybody who's over the age of 18 should be looking to make a will, even if they don't feel as though they have a huge amount of assets to pass on. It's still going to make the administration of their estate easier, and it does give the person, the will maker, some control over what happens. If you don't make a will, then the law has a certain formula that sets out how your estate is going to be administered, and it may not accord with your wishes. So I would say, as soon as you hear this podcast, or as soon as you sort of have enough space in your life to start considering it, I think you should do it.
So speaking of considerations, are there any additional considerations when you're making a will and when you have a child or beneficiary who has an intellectual disability?
Yes, Michael, absolutely. I think that there is. To the extent that the vulnerable or beneficiary or the disabled beneficiary needs special care, or they need to take into account how where they're going to be living, like accommodation, whether they're totally dependent or independent with occasional support, whether they're better suited to a group home or community or living with family. Maybe that might be siblings and so on. That all needs to be taken into account. We also need to consider their employment arrangements. Are they going to be working in mainstream employment fields? Are they going to? How many hours they're going to be doing during the week? Or if they're unemployed, what is their source of income going to be into the future? That certainly needs to be taken into account. We're looking at the, what are the education options for that child, whether there's anything different that might apply in terms of life expectancy, what are their future and current medical needs. So there's a whole range of questions that need to be asked, and even just really, quite basic questions like, the what are the support services, the support network that is there for them, and what is their current quality of life, and how and what kind of quality of life do you want your child to have going into the future, and also that sort of whole mix of questions around, are they going to need assistance in handling money? Are they able to, can do their day-to-day transactions? Are they, sort of wise long-term financial decision makers? And so we look at, their relationships with their health professionals, carers, their support network, their family and their friends to work out the best way to manage them receiving, an inheritance from their parents.
So are there any implications in the case of receiving inheritance? Are there any implications for a person with an intellectual disability when they actually receive that inheritance? And what I'm talking about there, tax impacts on tax or disability support?
Yeah, so this is one of the primary questions we have to get our heads around, because we don't want somebody who is relying upon the disability pension for the rest of their life to all of a sudden receive a huge amount of money that discludes them from being able to receive that benefit. So, yes, we need to, but at the same time, we don't want to overcook the situation, because if there are only very modest benefits that are going to be able to be given to, the next generation, then we don't need to, set up too much that's complicated. It might be the case that they could receive it in their personal name, but then they have the assistance of their community to look after those, that financial inheritance, with them. And so we're also looking at sometimes there can be a loss of eligibility for certain programs like supported employment, accommodation, and care that have their own criteria, and the loss of eligibility for the healthcare card, and that's all sort of tied up with the means testing needs to be taken into account.
Okay, so in the worst case scenario, what are the implications if a parent of a child with an intellectual disability passes away and they don't have a will?
Right. Well, so like I said earlier, there is a formula that's sort of written in the law. It's the rules of intestacy, and this changes. It's different for different states. So up here in Queensland, if you pass and you have a spouse, but no children, then it all goes to your spouse. And if you have spouse and children, then there's a sort of a split of assets between your spouse and children. If you have more than two children, then that formula changes again. So what's going to end up happening is if you have a person with a disability and say they're your only child, let's say, for example, then they will just receive everything in their personal name. And that might, depending on the amount of money that they will be receiving or value they receive, that might mean that they no longer are eligible to receive the pension. And so they would just be basically drawing upon that resource until they get down to a level in which they could reapply for the disability pension. So we do want to try and avoid that. And look, there's nothing dodgy about trying to avoid that. There are specific structures that have been set up, including the Special Disability Trust, which are designed to allow a person with a disability to have more than the assets test sort of level, but it's in that structure, that entity, and it has certain rules around it. So there will be a reduction in the flexibility in the way that the beneficiary can use those funds, but we can maintain the disability pension throughout the entire period by utilising structures. And so Special Disability Trust is one, and then a sort of a flexible, discretionary testamentary trust is also, a very useful tool for certain circumstances, for certain clients.
Okay, and so can a person with Down syndrome create their own will?
Oh, yes, absolutely. Yeah. So, there are different tests of, capacity. And so there's a different test, for example, getting married. versus, signing, a simple contract, versus signing a complicated contract, versus appointing someone as your attorney, versus making a will. And so the test for making a will is, really in brief, and this is from the rules of a court case from a very long time ago called Banks and Goodfellows. And this is that you need to understand who it is that might have an interest in your estate. So if that person with a disability had children, for example, or if they have a spouse, there's an expectation that you would provide for those people. They need to have an understanding of what their estate is. So, they need to know basically where they have their money, how much money they have or property that they have, just have a general sort of idea of that. And then they need to make sure that the people are, provided for, and that there's nothing that is affecting their judgment. Essentially that they're being influenced in any particular way, or that that there's any sort of element that is distorting their view of who should be provided for under their will.
Okay, so just I guess a bit more clarification on that. So if that does happen, that someone with Down syndrome wants to make their own will, do you have any recommendations for when that occurs and how to have those sorts of conversations?
Well, I think the first step is that you will want to have a lawyer write your will. I know that there are, sort of will kits and that available, and the, sort of the do-it-your-own approach, but there are significant risks involved in that. And, quite often it's the cheap solution that ends up being the very expensive solution, because those matters where there's uncertainty lead to, litigation. So having a lawyer write the will, they will, find yourself a lawyer that you can communicate with really well. You might find some lawyers that, that don't really have the time of day for you, if you did have a intellectual or, learning disability. So find a lawyer that is willing to spend the time that it takes to get to know you and what your needs are. And then, a strategy basically needs to be adopted that it takes into account some flexibility for the future is somewhat unknown. A strategy that takes into account, the tax implications and so on. And also takes into account, the emotional factors that are, relevant to the client. So, I would suggest getting in touch with lawyers and see if you can meet with a few, if possible, or at least until you feel as though you have the right connection with that lawyer.
Okay, you mentioned before in that comment about the cheap option is often the most expensive option. Can you tell us a bit about the importance of having and the advantages, I guess, of having a properly prepared will compared to a DIY kit?
Yeah. Well, first of all, you pay a lawyer to make sure that what is written in the documents it actually aligns with what you wanted. So you might write something into a DIY will and just not be aware that what you're writing could be interpreted in a different way. And so when you have different interpretations, different possible interpretations of a written document, then you have the recipe for conflict. And so if somebody feels as though they're being, an alternative interpretation favors their position, then you might end up with, litigation or, at least threatened litigation. Any time you get involved with litigation, you're talking about a huge amount of money that usually ends up in lawyers' pockets. So, although it might cost you a bit more in the front end to do your estate planning with the lawyer, it reduces your risk of things going wrong in the back end. And that, part of that is no doubt that lawyers are insured. And if you give instructions and the lawyer doesn't correctly prepare your documents, then, you have the actual potential that, to sue the lawyer. Whereas if you sort of just do things yourself, then you've got nowhere to turn. The results quite often, really quite atrocious. And, we've all seen, cases like this in the paper where, an entire state basically gets eaten up in legal fees. And sometimes it's just completely unnecessary. So, yes, I think that certainly estate planning is a lot better than, the trying to fix things after they've gone bad.
All right. So just going back to a question you mentioned before, that when you're looking for a lawyer, and if you're preparing a will, you may get one that doesn't give you the time of day. Are there any questions or advice you would give to people in regard to selecting a lawyer?
It's difficult to know before you met someone, whether they're going to be the right choice.
So I guess in that question, if you go and meet a lawyer, are there some questions you should ask them to really find out whether they're the person for you?
Well, I mean, I think understanding exactly what the scope is that the lawyer is going to do for you, and, the fees are an aspect of that, but really you want to understand, are we just going to have one appointment and then you're going to do my documents and then we're going to sign it up, and I'm not really going to have much of a back and forth, we're not going to have much of an actual sort of a guided journey through this process, or are we going to have a series of appointments, or are we going to have telephone conversations in between? I mean, when we prepare estate planning documents, there is the legal documents like the will and the enduring power of attorney, and in some cases, superannuation, binding death benefit nominations. Sometimes there's deeds and so on that have to go with family trusts, but there's also non-legally binding documents like memorandum of wishes, for example, that goes alongside the will and the enduring power of attorney, and that provides guidance to the trustees and executors and to the beneficiaries on what the overall aim is of the process and what the goals are that the testamentary, the will maker wanted. And so, just seeing whether, your package is actually going to include something like that, or is it just a sort of a bare bones type of arrangement?
Yeah. So when we mentioned when we talk about the importance of getting your will done, how regularly should you review your will and get it looked at?
Right. Yeah, that's a really good question. And this is a notorious area because people, about 50% of the population doesn't have a will. So that's, incredibly low. And that's not really good. And then of the people that do have wills, they often leave it, potentially decades before they update their wills. My advice would be to locate your will and to read it once every 2 years. So maybe at Christmas time or something like that, every second. It doesn't need to be every year, but every second year. And all I'm suggesting is that you read it yourself and you just think, okay, does this sound like what I want? Is everything still sort of as it is? It doesn't need to necessarily be reviewed by a lawyer every second year, but, read it yourself and consider whether it's actually reflecting your wishes. And if it doesn't, then you go see the lawyer. And if it does, then put it away for another 2 years. The times when, that you might be prompted to take more active steps to review your estate planning are, the birth of children or grandchildren, deaths, marriages, people moving in, separation is another important one. A lot of people don't know that when you separate from a partner, if you still have a will for their benefit, then that's not going to change by separation. It will change by legal divorce, but divorce is a year down the track at least. So as soon as you separate, you should definitely consider your estate planning then, and changing your beneficiaries around at that point. So those kind of major life events should be a prompt, but in default of that, just every 2 years, I think, just have a read.
And to finish up, do you have any advice for people, just general advice that we haven't covered, just about preparing your wills and your estate?
Well, look, one of the things I haven't really talked about is, what solutions are out there. And so, there are quite a few different paths that can be taken. And it does depend on, how you hold your assets at the moment. So is all of your wealth really tied into your family home? Or do you have, a share portfolio or some sort of investment on the side, or an investment home on the side? Do you have a large superannuation? And then we need to sort of go through a filter of, what are you trying to achieve, and what are the options that exist to try and achieve that, and then look at the pros and the cons of each one of those options. And so, a setup that is quite good, where you have a pretty, on the larger side of assets to pass on, is to set up, a testamentary trust in your will, a discretionary testamentary trust. And you could have, for example, it's a pretty common setup to have the siblings in charge of that trust, all children beneficiaries of that trust. And then for that trust to also have as a beneficiary, as a potential beneficiary, the special disability trust for a person with a disability. And so then you can be in a situation where the trustees have quite a bit of flexibility about if they can make distributions directly to the disabled child, or whether they set up a special disability trust and make contributions to that trust. There's also protections that will be passed on to your children in terms of the family law. If their children go through separation and so on, bankruptcy if their children are in risky professions. And there's also taxation advantages. As the law states at the moment, there is a rather large taxation advantage that happens with the distribution to minors from that trust. So I guess, it's taking into account not just the needs of the person with a disability, although that will be, an incredibly important part of it, but also the needs of their other children, and what can be done in the for the whole family. What's in the best interest of the whole family.
Okay, thanks for your time, Dion. We really appreciate you coming on today and having a chat to us. It's really beneficial to get this sort of information out to our families and members, so we can help them now and into the future and prepare for everything that's to come in life. Thanks very much.
You're welcome. It's been a great pleasure. Thank you for having me along.
At the Now and the Future podcast, we would love to hear your thoughts and questions as a way of continuing to provide essential information for the community. If you have a question or would like any more information on any of our episodes, or have any ideas for future episodes, simply send us an email to engagement@downsyndromeqld.org.au. That's engagement@downsyndromeqld.org.au. And we'll do our best to provide you with the information you require in one of our upcoming episodes. The Now and the Future podcast aims to support, advocate for and empower people with Down syndrome, both now and into the future.
You have been listening to the Now and the Future podcast. For more information about this episode and many other topics relate to Down syndrome,
Please visit the Down Syndrome Queensland website at downsyndrome.org.au/QLD.
Down Syndrome Queensland, supporting people with Down syndrome now and into the future.